Please excuse our tardiness. Traffic coming over from the American Bar Association building. And we thought we were allowing enough time, but we didn't. We didn't know how heavy the traffic would be. So we have, yes, I'm here. So Stephen, pleasure to meet you.
Nice to meet you, Mike. Hi, Dave.
Hey, good to see you. Good to see you. So what have we missed?
We have our last two.
Okay. So, is Regina here? Has she arrived?
I have not seen her.
Okay. Do you know how to pronounce Regina's last name?
I think it's Njogu. Njogu.
Njogu.
I think so.
Njogu. Thank you.
But you can ask her when she walks
Yes.
in.
Sounds good.
Hi, so I'm Carl.
Carl, Mike Greco.
So I think we're going to go ahead and get started. Because Bosco is going to sort of frame the issues. I think you heard about that in sort of the political context and so forth. And then we also have some announcements about other events from student organizations and things. So that will take a few minutes. And so Regina is apparently close by. So hopefully she'll be here very soon. And but we think that since everybody's waiting, we should get started.
Yes, I think that makes sense.
Okay, great.
David?
5 to 10 minutes.
Okay, good, great.
And then did you want to have each side present an opening statement of some sort? Steve, did you want to do that? It's just 4 to 5 minutes of sort of where you think's headed, or not
Well,
necessarily?
I mean, I have a series of questions.
Okay.
And so that, I mean, we have the alternatives are either if you want to make statements, if you want to make a
I
statement.
think I would prefer
Because
to respond to questions.
I have some good questions for you.
Good.
Okay, and then Tim is going to read the bios of everybody who's on the panel. Tim Kabiria, who I'm going to introduce when I'm done with my...
All right, so I don't need to do the...
Right.
Okay.
Right.
Great.
So you'll be able to just go right into the substance.
Sounds good. Sounds good. And is this your phone?
I think that's...
Or a micro? Oh, it's a recorder. I see. Okay.
Okay, so we're going to go ahead and get started. My name is Carl Levan. I teach here in the School of International Service at American University. Welcome. Thank you very much for coming to this event. It's actually been a couple of months in the works, and we're really excited that we have such an enthusiastic turnout, and we've had media inquiries, believe it or not, from all over the world. So put your best questioning face on when you ask your question once we get to the Q&A session. I teach courses on African politics, political theory, and in the PhD program. And this semester, this year, we have a series of events about African politics. And tonight's event is going to focus, of course, on the rule of law. The Africa Council here on campus. Our next event will be March 25th, where we will have 2 scholars who are experts on African legislatures speak about local and national legislatures in Africa, and especially how those institutions impact democracy and democratization. So I should say that the origins of this event came from a alumni and former student of mine and a friend of mine, Tim Kabiria. And before I turn it over to him, and he's going to introduce our speakers, I want to give the Student Organization for African Studies, recently renamed Africa Initiative, the opportunity to announce their upcoming event and talk a little bit about what they're doing on campus. Elizabeth?
Hi, I'm Elizabeth DeFries. I'm, excuse me, I'm Vice President for what's now named Africa Initiative. So we're kind of the student-run organization on campus who brings in events and panelists similar to the faculty organization. So our big upcoming event this year is the second annual African Ambassadorial Dinner. So last year we had 15 ambassadors come to American University, and ours will be April 16th. So I have, if you'd like to learn more about it or get to know, I have a list and you can put on your name, or if you're interested in getting involved in the organization, your class, and any questions that you might have. So thank you for putting this event, Professor Lalonde, and welcome panelists.
Thanks so much. Mr. Kabira, you want to go ahead and introduce the speakers and maybe describe the slight change in the speakers that we have also. So again, thanks for coming. My name's Carl Levan.
Thank you so much, Professor Levan, and thank you all for coming for this event. Well, mine is to introduce the speakers. First, my name is Timothy Kaberia. I'm originally from Kenya, and Professor Levan is my former professor right here at the School of International Service, and we approached him to get this event started. We were looking to have a discussion of the African cases, and we didn't have a way to really get it out. And when we approached Professor Levan, he reached out to other experts in the field. We got the American Bar Association. We got Mr. Lamoni, who is an advisor to the ICC on African Union and United Nations issues. And we got Professor Bosco here with us tonight. Let me just briefly introduce our panelists. From my left, we have Professor David Bosco. And David Bosco is an assistant professor of international politics. He's a Fulbright scholar and a senior editor at the Foreign Policy magazine. Bosco is a former attorney at Cleary, Gottlieb, Steen, and Hamilton, where he focused on international arbitration, litigation, and antitrust matters. He also served as a political analyst and journalist in Bosnia, and as governor, and as deputy director of Joint United Nations NATO project on repatriating refugees into Sarajevo. He is the author of Five to Rule Them. He is the author of Five to Rule Them All, which was published in 2009, A History of the UN Security Council, and his latest book, which is quite interesting, at least from the title, is Rough Justice, the International Criminal Court in a World of Power Politics. Mr. Bosco graduated with a JD from Harvard Law School. He got his master's from Cambridge University and his bachelor's from Harvard University. Next to Professor Bosco is Steve Lamoni, and he is a senior advisor on the African Union, United Nations, and Africa situations at the Coalition for the International Criminal Court. Steve is an international human rights lawyer, and he holds a master's degree in law and specializing in human rights law and criminal justice from the Queen's University Belfast in the UK. And he has a bachelor's degree in law from Makerere University, Uganda. Mr. Lamoni has been advocating for international criminal justice and an end to impunity for over 15 years. He has devoted his career to promoting and protecting individual and collective rights throughout Africa, and to challenging the impunity of gross human rights violators at the national and international fora, in the civil society, and in the research sector as well. He began his career in the war zone of northern Uganda. And we all know about the Lord's Resistance Army and all that, as a human rights monitor. While there, Mr. Lamoni monitored and investigated human rights violations between the Ugandan Army, or the UPDF, and the Lord's Resistance Army of Joseph Kony. He advocated for prosecution of perpetrators of these human rights abuses, and he's been doing this for a couple of years. Welcome, Mr. Lamoni. And today we are also privileged to have Mr. Michael Greco, who is a partner at the K.L. Gates Boston office. He is an experienced litigator with over 30 years, as well as a champion of human rights and the rule of law. Mr. Greco is a former president of the American Bar Association from 2005 to 2006, where he represented the American legal profession around the world. Additionally, he has been appointed to numerous leadership positions within the American Bar Association and the Massachusetts Bar Association. Of greater relevance to this panel is the fact that Mr. Greco is the chair of the Advisory Council of the American Bar Association Center for Human Rights and chair of the Board of Advisors of the American Bar Association International Criminal Court Project, a bipartisan, multinational distinguished board that oversees the ABA ICC project. Additionally, Mr. Greco teaches international criminal justice at the Peking University of Transnational Law in Shenzhen, China. And I don't think we can say anything more about Mr. Greco.
Please don't.
And then next to me, yes, we're supposed to be having Ms. Regina Jogu, and the last time I tried to reach her, she was in the parking lot, so we believe she's still coming. Let me give you a brief explanation of how we ended up with Ms. Regina Jogu. Initially, we had we invited the Kenya mission to the United Nations because we believe that the African cases basically have to do quite a bit to do with Kenya, but we have to be very, very clear that this was not just about the Kenyan cases. We are looking at the general picture of the African cases at the International Criminal Court. We were hoping that we would have Ambassador Koki Muli, but we got one that the ambassador is not available. Much as she had wanted to be here, she could not make it because the permanent representative to the Kenya mission in the UN, Ambassador Macharia Kamau, is out of the country. And the communication that we got was that they could not both leave the post at the same time. And so, for that reason, the Ambassador Koki Muli could not make it. However, we were fortunate to find Ms. Regina Jogu, who is a Kenyan lawyer, an alumni of this university. Actually, she went to Washington College of Law, and she's been quite involved in a number of issues that affect the African continent, and particularly on the Kenyan situation. She's spoken about the ICC cases in Kenya, about the political leadership, and I'm sure quite a number of people who are from Kenya here, or from Africa, East Africa, rather, they may know who Ms. Jogu is. So we are hoping that she'll be able to join us in a few minutes, because the last I heard from her was she was still on her way coming up here. And that's my brief introduction of the panel.
Thank you. Thank you very much.
Oh, you're welcome.
Great. So David will begin with some remarks.
Yep. Thank you very much. It's great to be here. I'm David Bosco, professor in the School of International Service, and I come to this panel and to this event as someone who's been very focused for the last 3 or 4 years on the International Criminal Court as an institution. As many of you know, the International Criminal Court is a relatively recent introduction to the international architecture. In the kind of pantheon of international institutions, it, I think, lays claim to being the most recent. It was negotiated in 1998 and formally opened for business in 2002. More than 120 states have now joined the court. Kenya itself joined in 2005. Somewhat unexpectedly, certainly unexpected to me, the Kenya case, and more broadly speaking, the African investigations that the ICC has launched, have become extremely controversial and in many respects have become a central challenge for the International Criminal Court moving forward. Some serious observers, diplomatic observers that I've talked to, have even suggested that the Kenya case in particular at this point poses an existential challenge for the court, and that could even threaten the eventual dissolution or marginalization of the ICC. So what I'd propose to do here in my very brief comments is to try to sketch out a little bit how we came to this point, how it is that we've had these controversial cases. And I'd like to first kind of provide an outline of the basic facts regarding the ICC's involvement in Kenya, facts that I suspect will be well known to many of you, but perhaps it's worthwhile to kind of review the chronology. And second, I'd like to discuss very briefly a couple of themes that arise from the Kenya-ICC interaction and that I think apply more broadly to many of the ICC investigations in Africa and beyond. So the basic background to the Kenya case is, of course, the violence after the disputed 2007 election in Kenya. According to most estimates, that violence resulted in the deaths of more than 1,000 people, with several 100,000 people having been at least temporarily displaced by the violence and the threat of violence. Several key international personalities attempted to negotiate an end to that violence, most notably former UN Secretary General Kofi Annan. And out of that negotiation process, both international and domestic, emerged a high-level commission of inquiry known colloquially as the Waki Commission. And it recommended a number of different things, but one of its key recommendations was that there be a special tribunal created, which would be a hybrid tribunal essentially, part national, part international, in order to investigate and prosecute high-level perpetrators of that 2007-2008 violence. But there was also an important provision included in the agreement, which was that if the national authorities failed after a certain period of time to set up an adequate mechanism to investigate and prosecute perpetrators, then the information developed by this Commission of Inquiry would be handed over to the International Criminal Court. And after a quite complicated back and forth and several failed attempts to set up a special tribunal, Kofi Annan eventually handed over to the ICC chief prosecutor, who is at that point Luis Moreno Ocampo of Argentina, a sealed envelope containing the names of the individuals that the commission believed were the leading suspects in the post-election violence. The prosecutor then took with that information, proceeded with his own investigation with the staff at the International Criminal Court, and in March 2010, the court authorized a formal investigation of the violence. And then in preceding months, the court proceeded to issue summonses for 6 individuals. Now, I'd like to highlight a couple of important aspects of the ICC investigation here. First of all, and for those of you who come from a legal background, it was quite important that this was the first proprio motu investigation by the ICC. And what that means is that this was an investigation initiated, launched by the ICC, rather than having been initiated at the request of a government or at the request of the UN Security Council. And for those of us who are quite interested in the trajectory of the ICC, that's a quite important development, because in a sense, that's a kind of declaration of independence or autonomy by the ICC, where it says we don't simply have to respond to what states ask us to do or to what the UN Security Council asks us to do, but we can initiate investigations on our own. That proprio motu power of the court was the most controversial element one of the most controversial elements at the negotiations that produced the ICC in 1998. A second important point is that the judges, the three judges who looked at the question of whether the ICC should open a formal investigation in Kenya, were split on whether an ICC investigation was appropriate. Two of the judges said yes. One of the judges said no, that the violence in Kenya, while deplorable, did not, in essence, meet the gravity threshold or the threshold of seriousness that the ICC should require before taking a case. So that is, I think, a very notable point. Finally, I would note that when the ICC did issue essentially indictments of these 6 individuals, it did so in the form of summonses rather than arrest warrants. And the reason it did that is because it wanted to position the ICC as being in a essentially cooperative relationship with the Kenyan government, rather than being in a situation of confrontation with the Kenyan government. And so the supposition, the working assumption of the court was that Kenya was going to cooperate and that these individuals were going to cooperate with the court's investigation and ultimately with trials. In formal terms, the ICC remains in a cooperative arrangement with the Kenyan government. And those summonses have not been converted to arrest warrants. However, as you'll hear, I think, in the course of this evening, that formal relationship of cooperation has many, many problems. And I think many would say that, describing it in practice, it's more of a confrontational relationship than a cooperative one. And to bolster that point, Kenya has, after those summonses were issued, undertaken a number of different challenges to the ICC investigations, both at the ICC itself, where there have been a number of challenges to the admissibility of the cases, at the United Nations, where Kenya has urged the UN Security Council to defer the investigations, at the African Union, and bilaterally with a number of key partners. Now, the case, of course, these investigations took a very dramatic turn in 2013 when 2 of those facing charges were elected to very high office in Kenya, and that is, of course, Uhuru Kenyatta, who was elected president, and William Ruto, who was elected deputy president, both of whom had been the subject of these summonses by the ICC. That has, to put it mildly, exacerbated the relationship between the court and the Kenyan government, which remains in a very unstable situation at this moment. Let me briefly highlight 3 themes that I think are important arising from this. First of all is the question of the relationship between international justice and justice at the national level. One of the basic assumptions of the International Criminal Court was that the ICC would be essentially a court of last resort, that it would be a place to go when all other options had failed, and the hope was that the threat or the possibility of ICC involvement would prompt national investigations. The Kenya case, and more broadly some of the other investigations that the ICC has done in Africa, I would say complicate that assumption, that the mere threat or possibility of international prosecutions will galvanize national prosecutions. And in one sense, Kenya appears to be a sharp blow to this idea, because the notion of the Waki Commission and Kofi Annan was precisely to use the ICC as leverage to get the Kenyan government to take steps at a national level. That did not pan out, and it really has not panned out to this day, where there have not been serious investigations of that violence in Kenya. A second theme is the relationship between justice, on the one hand, and political reconciliation, on the other hand. This often gets discussed in terms of peace versus justice. And the question, of course, is whether in pursuing investigations and prosecutions of individuals in fragile post-conflict societies, do you threaten, in essence, the reconciliation that has been achieved? Do you threaten the fragile peace that has been achieved by insisting on investigations and prosecutions? That is a theme that the Kenyan government has hit upon several times in its objections to the ICC case, is that this threatens to kind of undo the fragile peace that has existed in Kenya since the 2007 violence. Other people, of course, believe that this is nothing but rhetorical cover for a continuation of impunity. A third theme, a final theme, and the one really that I'm most competent to address, is the nature of international justice and the concern that international justice is not being administered fairly. Specifically, of course, the issue is the African focus of the International Criminal Court. Now, there's plenty of disagreement about this topic, but there is one thing that is not in dispute. Every full investigation by the ICC has been in Africa. Every person indicted by the ICC has been African. That is despite the fact that there have been serious crimes against humanity, war crimes committed in a number of other places, including places where the ICC has jurisdiction, such as Afghanistan, Colombia, and Georgia, just to name a couple. Now, one should not have the view that the Kenya case is itself the sole determinant or the sole cause of tension between Africa and African officials and states and the ICC. In fact, that tension has long predated the Kenya investigations. When the ICC indicted Sudanese President Omar al-Bashir, there was a very strong, very negative reaction from the African Union, and the Kenya case has really just exacerbated that tension. I think many people would say that the relationship between the ICC and the African Union is perhaps at its lowest point now that it has been. A number of African states have suggested that they might actually withdraw from the ICC. It's a little bit hard to know how seriously to take these claims, but if that were to happen, if you were to have a number of African states withdraw from the Rome Statute, that would pose an existential threat to the ICC, not only because all of the ICC's investigations are there, but also because African states as a bloc are the largest single bloc in terms of overall ICC membership. So the Kenya investigation, the Africa investigations more broadly, are a central issue for the ICC and for international justice more broadly, and I think I'll leave it at that.
Good. Welcome.
Thank you.
Traffic was an issue?
Traffic, yes.
Yes, I'm familiar with that. I was late too. So.
Oh, okay. That makes me feel better.
Yes. But David, thank you for that wonderful overview. This sets the table in a very direct way about what we're going to be talking about this evening. I would make one comment about your last point, David, your third theme. When you mentioned that all of the situations in Africa that the ICC has pursued have been in Africa, what must be said after that statement is that all of the Africa situations, except Kenya, have been referred to the ICC by those African countries. Got that point? Okay. Now, before we begin the format of the program, which will be that I will ask questions of our panelists.
I want to give Stephen, you, the opportunity to say anything by way of introduction, as David has, and also you, Regina. So let me stop and ask whether you want to comment on anything that we've heard so far.
Sure, thanks, Michael. I would like to start by commenting on the threat of withdrawal. It's not the first time that you hear of the threat for withdrawal. A lot of you remember that the first threat for withdrawal came in 2009, June of 2009, when the late Gaddafi was president of Libya. And at that point, he was responding to the indictment of the Sudanese president and threatened then that 36 states from Africa would withdraw. That was firstly statistically wrong. Then there were only 32 African states. To date, there are 34. Of course, the threat for withdrawal has continued at the recent extraordinary summit that I attended in Addis Ababa. It was brought up, but it did not gain any traction because a number of the states' parties told of the Kenyan government very clearly that when they decided to sign and ratify the treaty, they never went to Kenya, they never went to the African Union to request for their permission to join the treaty. And at the end of the day, if they were to withdraw, that's a decision that has to be made by their own parliaments. The same issue was brought up at the brainstorming session of the AU discussing the impact of ICC, December 17th to 18th, brought up by Rwanda and Sudan, and it was again dismissed. It will continue to be a threat, but it's not something that is very serious because African states parties know what their commitments to the Rome Statute are. The last comment I would like to make is the essential situation that we find ourselves in. The creators of the Rome Statute during the Rome pre-conference discussed the very situation that we find ourselves in today, namely a situation where you have a sitting head of state being indicted. During discussions of the Rome Statute, a number of heads of state did speak of how senior government officials and military officials were committing crimes dating back to the 1940s. And it was for that very reason that Article 27 was included in the Rome Statute. It's one thing, of course, to have it in theory, and then the practice of having to implement the proceedings against the sitting head of state. I'd like to stop there for now.
Okay. Thank you. Regina, you've somewhat of a disadvantage coming in a little late,
Right.
but if there's something preliminarily that you'd like to say, do, or you can wait until after I start asking questions.
I think I'll wait.
Good. Okay. Well, let me make a couple of comments before we start the questioning. And you heard the introduction of my background, but there are a couple of things that weren't included and that I'd like to mention. One is that my son, Christian, is a graduate of American University, and so it's a pleasure for me to be back on the campus and to be participating in this program. So I wanted you to know that. Secondly is that when I was president of the American Bar Association in 2005 and 6, one of my official trips abroad was to Kenya. I spoke in Nairobi. I spoke to prosecutors from a number of African nations on the subject of human trafficking, which 10 years ago was less understood as a threat not only in African countries but in the United States. This past year, the ABA took on human trafficking as a priority of the legal profession. But my trip to Kenya was very eventful for many reasons. So I have some firsthand observation of the situation in Kenya, which was very different than it is now, especially after the 2007 and 8 elections. And the other point I want to make is that the American Bar Association has long been a strong supporter of international criminal justice. Going back to the 1970s, the House of Delegates of the ABA, which is like our Congress, 550 delegates from all over the United States and abroad. We meet twice a year, February and August. We debate policy resolutions. We adopt policies. And in 1978, the first policy adopted by the ABA regarding international criminal justice was to endorse the idea of the creation of a permanent tribunal. And that was followed by 5 other policies. Most recently, the policies have had to do with support for the ICC itself, which, as you heard, was created in 1998 in Rome and became operational in 2002. Why has the ABA consistently, for now more than 4 decades, supported strongly the creation of an permanent international criminal court? Simply, from the end of World War II to 1990-91, the promise, the vow taken after the Nuremberg trials that never again will we permit atrocities like the ones that have happened to happen again. Never. That promise, as heartfelt as it was wrong, because the atrocities have not stopped. If anything, they are worse today than they were during World War II. But the climate wasn't right for the nations of the world to come together as they did finally in 1998, 160 some nations going to Rome, Italy for 2 weeks. And in 2 weeks, an extraordinary thing happened. 160 nations and their representatives, and the ABA had its delegation there, coming together to acknowledge the need for a mechanism to deal with the never-ending atrocities. And so the creation of the Rome Statute, which is a treaty and a statute, was not only an extraordinary event, because so many nations came together, it is the first statement of mankind that there must be a mechanism for dealing with the evil side of humanity, which exists. And so the ABA, from 78 to now, has found ways to try to help the advancement of justice internationally. And since the creation of the ICC to now, more recently, and I'm involved in these efforts, and Kip Hale, who's standing in the back of the room as senior counsel to the American Bar Association Center for Human Rights, Kip and I and others at the ABA have been meeting with the leadership of the ICC for the last 18 months. We have had discussions on how some of the efficiencies and effectiveness of the court might be enhanced. The American Bar Association, together with many organizations throughout the world, are offering to share our best practices. The judges and prosecutors of the U.S., the best of the best, and those of Europe and Asia, stand ready to assist the court to deal with whatever issues that the court asks us to help address. Now, so the bona fides of the ABA are there. We are not recently to the dance. We've been there for the last 45 years. So it pains me to see the kind of challenges that are posed by the Kenya situation to the ICC. All the other tribunals that you may have heard about, the creation in 1992 by the United Nations Security Council of the special tribunal, the independent tribunal for Yugoslavia, the former Yugoslavia, because of the genocide that took place during that conflict. 2 years later, the creation by the UN Security Council of the special tribunal for Rwanda, followed by other specific newly created courts dealing with situations in Lebanon, in Iran, in Sierra Leone. The International Criminal Court will be the only court surviving after these other courts have been transitioned out. And the transitioning is happening right now. So that by 2016 or 2017, there will be no ICTY, Yugoslavia. There will be no Rwanda or these other courts, other than to finish up their work. So the only remaining vehicle in the world will be the International Criminal Court. I submit that the position of the ABA for the last 4 decades in helping to create such an institution and helping to advance it and now helping to protect it, I want you to understand how serious it is, the possibility that the court would cease to exist or would be crippled or hampered by the erosion of its core. And so what we're talking about tonight was referred to as an existential challenge. I think that's right. It's a challenge to the very existence of this institution. And I would ask you, after we finish this discussion and you're on your way home or wherever you're going, ask yourself, can we permit the elimination of the International Criminal Court? That's a question that perhaps our discussion will help you answer as you hear what the alleged failings of the court have been with regard to Kenya and its accomplishments. So I will say no more about the ABA's involvement other than that we continue to have complete confidence in the court, and the need for the court, I think, is self-evident. Now, I want to begin by quoting something that I read this afternoon, and this, I hope it doesn't steal any of your thunder, Regina.
Hopefully.
But it may help you make your points. Because what I read was a speech that was given by the Ambassador and Deputy Permanent Representative of the Republic of Kenya to the United Nations, Ambassador Koki Muli?
Yes, Muli.
Muli Grignon?
Yeah, Muli, M-U.
Yes, Muli and then Grignon, who couldn't be with us tonight. But I assume that if she had been with us tonight, she would have made the points that I'm going to quote from her speech. And I have a purpose for quoting these two statements. First, she said, Kenya to the UN, April 2013, Mr. President, Kenya fully supports the international criminal justice initiatives, the Rome Statute, and the International Criminal Court, the ICC, not just because we were co-authors of the Rome Statute, but because Kenya believes in the rule of law, justice, reparations for victims, and the necessity to end impunity. However, Kenya strongly objects to the politicization of the ICC, and particularly the Office of the Prosecutor. Kenya also notes the selective application of the universal jurisdiction of the ICC and the selective referrals from the Security Council. This conduct undermines the credibility of the ICC and other tribunals and can sabotage national and regional peace, security, and stability. This in turn leads to the weakening of the international criminal justice machinery. I will not read the other parts, but I want you to understand that when we hear from the ambassador to for Kenya, speaking to the UN, about reiterating Kenya's commitment to the rule of law and commitment to the International Criminal Court, one must ask, how genuine are those statements when, as you will hear as we go through the questions, facts about what Kenya in fact has been doing for the last 3 or 4 years with respect to these commitments that it so eloquently states at the UN. And so keep an open mind about what the court has done and whether whether the court deserves the kind of criticism that has been leveled by Kenya. So in a sense, what we're doing here tonight is hearing a case. And what's important is that, for you to understand, is that the court is not here. Why isn't there a representative from the ICC here? Because the Rome Statute, among other things, urges states parties and others, especially during a litigation which is ongoing, not to comment publicly about an ongoing situation. So it would be inappropriate for the court to have a representative here. In fact, there are critics in the U.S. who say that why is Kenya permitted to try its case in the press and publicly when there is a restriction on that they've agreed to? Kenya has signed the statute, the treaty. These are procedural issues that shouldn't get in our way, but nonetheless understand that when there is an accusation and the court itself cannot respond, it is this kind of a forum, a neutral forum, where you will hear statements made about, is that true? Is that accurate? Is that valid? And the last thing I'll comment on is that the reason I quoted the ambassador's remarks is that it is troubling to know that on the other side of the equation are those who in the U.S. who say, well, if Kenya truly believes in the principles reiterated by the ambassador to the UN, then why has Kenya not cooperated with the ICC and the prosecution to provide access to evidence, to documents? No cooperation whatsoever. The interference with witnesses who are willing to testify and then magically they disappear or they are no longer willing to give testimony in the Kenya situation. The intimidation of witnesses. Who is doing it, and why is it happening in Kenya? Under complementarity, as Professor Bosco said, the ICC is a court of last resort. The first line should be up to the national courts, in this instance Kenya. Kenya, under the Rome Statute, has an obligation to investigate and prosecute if the evidence is there. What has Kenya done since 2007, the violence? Has there been an investigation? No. Has there been any indication of prosecution? No. What I'm doing is giving you the rhetoric that we're hearing and then giving you the facts about the actions. And I think you have to decide where the truth lies. So with that kind of some controversial opening observations, now let me ask the panelists some questions. My first question is to Stephen. And Stephen, I want you to first of all, give us your sense of the public support in Kenya, if you wish to, for the current cases that are before the ICC that are from Africa. For example, where do the victims of those situations stand, generally speaking? So if you perhaps just begin by giving us the brief overview of the 8 situations and how they got there and what the status is and what the reaction is in Africa regarding those situations that are before the ICC now. I believe there are 8 of them.
Sure. Thanks, Michael. And I'd like to start off on that note. Of course, like both you and David rightly pointed, Africa, I went to the ICC 5 times, demanding that the ICC should come and to look into their situations and conduct investigations and prosecutions. I'm talking of situations in Uganda, Central African Republic, Mali, Cote d'Ivoire, and the Democratic Republic of Congo. In all those situations, African leaders themselves went to the ICC and requested for intervention. The reasons vary from situation to situation. The DRC, the judicial institutions were not functioning. In Uganda, Uganda was unable to arrest Joseph Kony and a number of other reasons. In 2 of the situations, you had UN Security Council referrals. In the situation of Libya, you have unanimous support. You had African members of the Security Council, Nigeria and South Africa supported the referral. In the situation of Darfur, Sudan, you had 3 African members of the Security Council. Only Algeria objected to it. Benin and Tanzania did not object to it. Like David rightly pointed, it's only this situation in Kenya where the ICC officer prosecutor basically came and opened up investigations after there had been several initiatives dating back from 2009 where the Kenyan Parliament had discussed and on several occasions failed to establish local mechanisms and the special tribunal for Kenya. At that time, a lot of you remember that the Deputy President of Kenya currently, William Ruto, was one of the key people saying that let us not be vague, let us go to The Hague. Okay, so since then, of course, Ruto has continued to cooperate with the court. I'll talk about that later on. With regards to public support for the ICC in Kenya, there have been a number of opinion surveys that have been conducted. The latest was up to last year where there was about 50% support of the ICC. That support has been declining for a number of reasons, and I'll outline to you why that support has been declining. Like Michael, you rightly said in your opening statement, the Kenyan Deputy Ambassador talked of their support for international justice, supporting the rule of law and the ICC and a number of things. I would like to start by looking at it from 2 sides. It is true to a certain extent that the Kenyan government has been cooperating with the ICC in terms of allowing ICC staff to go into Kenya and conduct investigations, allowing the ICC open up a field office where they can operate there. However, as a number of you will have observed at the recent Kenya Status Conference, there have been 3 main challenges that the Office of the Prosecutor and the ICC continue to face. Michael has touched on some of them. I'm going to talk about them in detail. The first threat continues to be witness intimidation and interference. In a recent filing by the Office of the Prosecutor, she did mention that this level of witness intimidation and interference is unprecedented. To date, the Office of the Prosecutor spends 80% of their time, which is dedicated to looking at the Kenyan cases. The Kenyan case has become a moving target because of this intimidation that has impacted on their investigations, where in the past they have collected statements from victims. The next minute you find these victims or witnesses coming up in an affidavit saying that they cannot go ahead and testify against the head of state, their own head of state, because there is the threat from their community that will come back and hit them. The intimidation has gone as far as Kenyans who are out in the diaspora. One of the witnesses that recounted evidence from the United States, others are in Europe. So this is a very highly unprecedented level of intimidation. Also, getting new witnesses is becoming problematic because of the fears that I mentioned, and yet at the same time you have the Office of the Prosecutor getting evidence or testimony from victims, and they need to link this evidence that has been given. Because of the climate of fear, it's becoming problematic, despite the fact that the prosecutor continues to conduct investigations. Lastly, there's been a fear campaign against civil society organizations through the social media, and in other cases where you have human rights activists that have been intimidated or threatened by supporters of the government has done nothing. Mike also talked of the records that are needed to corroborate the evidence that's been given. A lot of you remember that last week during the status conference, the issue of government obstruction was clearly painted out in the media. The OTP has requested for evidence for the phone records from the president, judicial records, and records of helicopters. Of course, the Attorney General gave a reason saying that they have no obligation to cooperate with the prosecutor. And yet you have to note that this is a very nonsensical argument, because for the past 2 years, the Kenyan government has been selectively cooperating with the ICC in providing some of the records. Why is it at this point that after the Office of the Prosecutor has filed a complaint of non-cooperation that you find that the same government official is claiming that they have no obligation to cooperate with the Office of the Prosecutor? The last point I would like to make on that issue is that, of course, the ICC is perceived to be an enemy of the people in Kenya, because the ICC needs to cooperate with other states parties in Africa, either to relocate these witnesses or victims to other states or get evidence. Now, because of the whole politicization of the Kenyan case, a number of states parties in Africa are saying that they're willing to cooperate with the court, but not as far as the Kenyan case is concerned. This goes further than the African state because of the whole rhetoric that has been painted right from 2009 from the Omar al-Bashir case that the ICC is an imperialist and racist cause. You have other states outside Africa not wanting to be associated with the ICC. So this continues to be a continuous problem. The last point on the issue of victims, the legal representative of victims for cases in Kenya have been very clear that the victims in Kenya have been demanding for justice and saying that there should be no delay for victims of justice in Kenya. The accused persons should be held accountable, and this is something that was echoed very clearly at the ASP 12 in November, where you had the legal representative of victims and a lot of Kenyan civil society organizations come up and say that they want justice to be done, and the discussions at the AU blatantly leave out the issue of victims. So victims in Kenya definitely want justice.
Okay, thank you, Stephen. Regina, I'm going to ask you a question. And I'm going to give a little background and then the question.
Sure.
The background is that Kenya, during the years 1997 to 1998, was a member of the UN Security Council. Kenya at that time voted in favor of UN Security Council Resolution 1207, which calls on all states to cooperate fully with the International Criminal Tribunal for the former Yugoslavia, including to comply with its requests for information and investigations, and to otherwise, quote, cooperate fully with the prosecutor in the investigation of all possible violations within the jurisdiction of the tribunal. We're talking about Yugoslavia tribunal. Kenya voted in favor of what I just read. At that time, the ICTY, Yugoslavia, was handling cases of the most senior leaders in the former Yugoslavia, including then head of state Slobodan Milosevic, who was indicted a year later in 1999 and tried in The Hague prior to his death. Now, my question, can you explain why Kenya would once support criminal accountability for heads of state in 1997, 1998, but now takes the position that sitting heads of state should be immune from prosecution? That's the question.
Okay, thank you. First of all, I would like to clarify that I'm not representing the government of Kenya. I am not speaking for the government of Kenya. I'm a private citizen, Kenyan citizen, US citizen, and everything that I'm going to, my opinions here are my opinion. Now, coming to the question, when you talk about former Yugoslavia, I would like to say that the Yugoslavia case and the Kenyan case are not the same. The former Yugoslavia case is unique in its history, background, scale, and dynamics. I'd rather focus on the specific reasons why the Kenya government has taken the position that it has taken, to my understanding and in my opinion. I have a few points to make on that issue. Number one,